being conscious of everybody's time today, I want to welcome you to the Diversified Planning Solutions Mentoring Forum, and it's sponsored by California Lutheran University's Financial Planning Program. Just want to give you a little information about our program here. The Financial Planning Program at Cal Lutheran, we have an MBA in Financial Planning degree. We have a Master's of Science in Financial Planning degree. And we also are just starting out with a minor in Financial Planning. And so the Financial Planning Program here at CLU is sponsoring this presentation. So I'm going to turn it over to Terry Bradford Crane, and she's going to introduce our guest speaker for today.
Thank you so much, Cindy. As Cindy said, my name is Terry Bradford Crane, and we are very fortunate today to have John Thiel with us. He will be talking to us today about buyout agreements. So hopefully everybody will get something out of this. I'm excited to hear about what he has to say. John is a recent addition to Marin County's private ocean, which is in Sacramento. He has a passion for wealth management, which started at a young age. And talking with his family's financial advisor, he found he really enjoyed learning how to best manage money, and was really intrigued by the diverse world of finance and business. Prior to joining Private Ocean in 2019, he was an advisor at Fountainhead Wealth. And before that, he worked at Northwestern Mutual and Mass Mutual, specializing in risk management and insurance solutions. He has a Bachelor of Science degree in business with a concentration in international business. He, of course, has a CFP designation and is currently studying to earn his MBA in financial planning with this very program. So, John, thank you so much, and teach us something great.
Wonderful. Thank you for the introduction, Terry. It's been a pleasure being in the program. And the only thing I would correct in there is that Private Ocean is just north of San Francisco in the Marin County area. But other than that, thank you very much for the introduction. And I look forward to presenting about buyout agreements. So next slide, thank you. So our objectives for today in this presentation is that by the end of this lesson, you should be able to better understand the importance of buyout agreements, analyze when a business should seek an agreement, describe the costs of not implementing such an agreement, and discern between two very important provisions that are inside of them, right to forced sale and first right of refusal. Next slide. And I should just let you all know, I know we gave an introduction for me, but this presentation is for informational purposes. If you go to structure a buyout agreement, I recommend getting legal advice or having an attorney review those documents. Thank you. Okay, so what is a buy, sell, or a buyout agreement? Well, much like a prenuptial agreement, a buyout agreement gives owners a way to deal with ownership disruptions in a way that won't wreck their business by providing pre-established rules for transferring interests. And so as a definition, a buy, sell, or buyout agreement, which I'll be using interchangeably, is a binding contract between you and your co-owners that controls when an owner can sell his interest, who can buy an owner's interest, and when the company or co-owners must buy another owner's interest and what price will be paid for that interest. So you can see there's a lot of levels that are going into this, and it's meant to catch a lot of areas when these types of events happen. And throughout this presentation, I'll be covering each of those. Next slide. But before we go into who needs it and why that's important, I'm just going to cover real quick who might not need a buyout agreement. So one example is if you're a 100% sole owner of a business, and maybe you're just planning to have the business die down with you, you're not planning to pass it on to someone, In that situation, it might not make sense to do it because it's meant for multiple owners or transfer of ownership. But if you have a employee who you believe is very valuable and you want to maybe transfer the business to them in the future, well, then you might consider it. You own the business with your spouse, and so you believe that you and your spouse are going to be the only owners in the long term. But even in this case, marriages don't always work out, and so it might make sense to have a buyout agreement within the business, or have something in the prenuptial agreement if there is that in the marriage. You own a business with one of your children, so you're just planning to pass on the business to your children, and you feel like, well, I don't really need an agreement to do this. And while there might not be as much of a need as if there was 3 owners of a business, say, that aren't in the same family, it might still be a good idea in that case, because you may want to plan for death, disability, or other factors that can affect the owner and their child. Next slide. So now that we've covered that, what are the dangers of not having a buyout agreement? And while there are many, I've boiled it down to 3. You may be forced to work with an inexperienced stranger. If you leave the company or die, you or your survivors may be stuck with a small business interest that no outsider wants to buy and for which no insider will give a decent price. So there's 3 owners, one of them passes away, and the deceased owner's family needs, those funds because they've poured all of their money into the business. Are they going to be able to sell their interest in the business in order to weather through the transition that they're going through? And also, co-owners may argue on the value of ownership interest that is changing hands, wreaking havoc on your business. So that's going to be very important in terms of all the owners agreeing on a price and having a way that they can conduct that. Next slide. So some triggering events where a buyout agreement is going to be really coming in handy is often going to be when there's troublesome shocks and events that are happening in one of the owner's individual situations. And not all of them are troublesome necessarily, like when an owner wants to retire. That can become a very smooth transition. But if an owner gets disabled, divorces, loses their license, they're in bankruptcy, they default on a loan, or they pass away, those are all instances that could end up creating a shock in the business, and you want some kind of template to work with it. Also, if an owner is being unreasonable and they're not conducting themselves appropriately, maybe they need to be expelled. And then we talked about if one owner passed away, can their family ultimately sell their interest, or can the existing owners of the company, can they buy out that interest from the family of the deceased spouse? So these are important events that would trigger a buyout agreement most often. Next slide. So I have an example here. In the interest of time, I'm going to move quicker past it, but ultimately it gives a situation where one of the owners divorces with their spouse, and now that spouse becomes a part manager in that business, a part owner, and there becomes infighting within the company, and ultimately it doesn't work out. So this is just one in hundreds or thousands of situations that could happen, and why it's important to put something like this in place. Next slide. So within a buyout agreement, although there can be there's many provisions, these are 2 very important provisions that I want to touch on for this presentation. So the first one is the first right of refusal. And that requires an owner to first offer his interest for sale to his company and co-owners before selling it or transferring it to anyone else. And this is important so that there's 3 owners and one of the owners decides to suddenly sell it to someone that all of the other owners don't know about. And then suddenly one day the other owners see this new owner come in that they've never met before, that's a stranger to them. That could create a lot of problems. So having a first right of refusal makes it so that they can restrict it restricts who the owners can transfer their interest to and sell to. So they can make it so they can only transfer to inside parties, or they can make it so there's restrictions on the outside parties, but ultimately it requires the owner to first offer their interest to the other business partners before outside parties. Right to force sale requires either the company or its remaining owners to buy out an owner who wants to leave. So this could be important if in the early stages of the company, an owner leaves and isn't participating. Perhaps the other owner, if they're not going to be managing the company anymore, the owners would want to be able to buy that interest from them, and they can force that with this provision. And then there's a lot of sub-provisions to each of these that can be implemented. So I give an example of financial disincentives. In the early stages of a company, it can be a lot more vulnerable. And so if an owner decides to say, leave within the first year, the other owners can make it so that they're like, okay, we'll buy out your interest if you leave in the first year, but we're going to buy it out at a really deep discount. We're going to buy it out for 10% of what we think it's worth. But every year that you stay in the business until it becomes successful in X amount of years, say 5 years, then we'll be able to buy it out at 100%. Next slide, please. So digging in a little bit deeper on the first right of refusal considerations, when an owner is considering an outside buyer, it's really good to have a proposed buyer provide a signed notice of intent to transfer so that they're more committed. Consider having a down payment with a notice as a sign of good faith. And this helps that maybe if there's a disgruntled owner, they go out and they find someone who's willing to pay this outrageous price, or at least say they are. And really the disgruntled owner is doing that so that they can try to get the actual inside owners to bid up their prices and then essentially buy that person out for maybe not what it's actually worth. So this helps defend against that. In helping with that, have an agreement that the continuing owners buy an owner's interest under the right of refusal at a set price, or an agreement price, at a predetermined in the buyout. So essentially, if everybody knows the value of the business and you say, when this type of event happens, it's going to be at these prices, that can help prevent against that situation I talked about, where someone's trying to bid out their price at this really high inflated price. Next slide, please. Right to force buyout consideration. So there's 2 prongs to this. You can have the option to purchase and owner's interest. And this gives your company and its owners the right to purchase an ownership interest from an owner or her estate or her family members, but they're not obligated to do so. So you have 3 owners, one of them passes away, the deceased owner's interest goes to the family. They could leave that interest with the family for a period of time, but if they ever want to force a buyout, they could. You can have it the other way around, where that family can decide that they're just going to hold on to the interest in the business, but if they ever want to sell it, then they can force the issue. And then you have right to force sale. And this option requires that the company or its owners buy out an ownership interest from an owner, her family members, if the departing owner or her family members make the request. So in the option to purchase, that one makes it so there's the option they can do that. The right to force sale makes it so that they can force the issue. Next slide. Important to know, if all parties agree to restructure their buyout agreement, it can indeed be restructured. And the point of this is saying is that in the beginning, when everybody signed it, if it needs to be restructured, everybody can sign it and make that change. The thing I would add to that is if that happens, make sure that all of the business owners, spouses sign it, or anyone who stands to inherit. Next slide. Buyout structures. So when these events are triggered, how does this transaction actually happen? How is it involved in terms of the owners? So there's 3 structures I'll go through. One is the company as the buyer, and that's called an entity purchase buyback. And that's where essentially the entity itself purchases ownership interest and cancels it out, in effect increasing the owner's interest. So if there's an LLC with 3 owners that have 33.33% interest in the company, then essentially when one of them leaves, say they're retiring, the LLC will purchase that person's interest to buy them out, and then it will dissolve that interest so that the remaining owner's 33% interest goes up to 50% each. You can also have co-owners as buyers, and this is called cross-purchase buyback. And that's where the continuing owners purchase shares typically in proportion to the amount they already own. So if you have majority and minority ownership holders, that it can help to have a provision that clarifies that. The thing about doing it that way is it can get complicated when you have more than 3 owners. Say there's 4 or 5 owners, figuring out who's going to buy from who can become very complicated, especially when you include insurance as one of the mechanisms for doing so. Next slide, please. And then there's also the wait and see approach, which is essentially the combination of the two. And this is essentially where you can have the entity purchase interest from a owner that's leaving, and then whatever's left over, the individuals can buy out the interest. You can also have that in the opposite order as well, where the owners do it and then the company. The point of the wait and see approach is that it offers the greatest amount of flexibility. And so it's helpful for maybe having that flexibility with the finances in the future. But the thing about figuring out how to fund this is the earlier you can plan it, the better. So there's pros and cons to having a wait and see approach. Next slide. So speaking of funding, there's many ways that these can be funded, but I'm going to cover these 4 ways that it's done, as they're some of the most common and probably a combination. One is through cash, but doing a buyout with cash is very expensive because it requires the company to have a large cash reserve. And that capital could be allocated to somewhere more efficient. Borrowing money, that's helpful because they don't have to have the cash reserve, but it could be potentially difficult getting a loan. What if the company is out of credit? What if after losing a owner, now the lender is like, well, it looks like, you know, you guys aren't going to be maybe as successful, so we'll lend this money to you, but at a very high interest rate. Buying insurance can be helpful because this can be funded over time, say life insurance or disability insurance, so that if an owner dies or gets disabled, they have that policy to help fund it. But you can't insure every buyout situation, such as defaulting on a loan, divorce, bankruptcy. So you can use it for some preventative times when doing a buyout, but not every case. Also, it depends on the health of the owners. They have to be able to qualify for the insurance. And it can also be done through installment payments, where they essentially agree maybe over 3 to 5 years that they're going to buy the owner out on a note. And this may require the staying owners to lower their income a little bit and use that cash flow to buy them out. Probably what would happen is there would be some combination of all of these, and there's also other creative ways this can be done. Next slide. But in order to facilitate the funding of the buyout agreement, everybody needs to agree on the price. So here's 5 ways that a business can be valued. Now, you could have a whole webinar series on how to value a business, but I'm just going to touch on these briefly. One is agreeing on a fixed price. This can be helpful early on. In the first year, if nobody really knows the value of the business, everybody can just agree on a price, because having a price as opposed to no price puts them in a much better situation, especially if creating a buyout agreement kind of falls on the wayside. It's better to have something that people can work from. Another is book value, where you take the assets of the company, you subtract the liabilities, and that will give you the value of the company. If this company has a very good reputation in the community, has very good connections, lots of good suppliers, you might think, well, you can subtract the assets and the liabilities and get the book value, but I think this business is going to be worth a lot in the future. So you determine a multiplier based on the goodwill that that business has built. There's capitalization of earnings, where you take the gross revenue, you subtract the cost of doing business, and you get the profits or earnings, and then you times that by a multiplier or a capitalization rate. All the research in this one comes down to the multiplier that's used. And typically you won't want to use this method until you have at least 3 years of earnings, because you're essentially looking at all of the cash flows, trying to project in the future, looking at the economic environment, and all this data and research goes into figuring out what that multiplier is, and then timing it times the process to get a value. And then lastly, you can always have someone come and appraise the business. In fact, you can get 3 appraisers come and appraise the business, and you could take the average of them. The thing about using an appraiser is everybody has to trust them, and you have to be willing to pay for them. It could be very expensive to hire appraisers. Next slide. But, you know, in business, not everything goes well all the time. There can be disputes, and those disputes can be very costly. So having an alternative dispute resolution clause in the buyout agreement can help resolve resolutions out of the court through negotiation, mediation, arbitration. The main idea is to be able to have the owners maybe come to an agreement, or hiring an independent third party as the arbiter to help decide you know, how this case is going to end, because going to court can be very costly and hurt the reputation of the business. It could end up just not having any money left, whereas doing arbitration can be cheaper. Usually a little bit more leniency in terms of the common sense that can be used. You can bring in experts. Now it can be binding, which means that the decision can't be changed, or it can be non-binding. But typically once an arbitration case finishes, it can be hard to then try and go against that and win in the courts against that. So having these provisions helps protect the interests of the owners. Next slide. And when it comes to finalizing the agreement, a buyout can be placed directly in the Articles of Incorporation, the operating agreement, the partnership agreement. So it depends whether it's a corporation, LLC, or a partnership, or some other type of structure. But the best practice is to have it as its own separate document that the owners sign. And not only do you want to have the owners sign it, you want to have their spouses and the inheritors sign it so that they can't contest it later. However, it is a good idea to have the buyout referred to in the business's primary document, so that maybe it's in the Articles of Incorporation saying there is a buyout agreement that exists. One other thing I'll add to this is it's a good idea to put on the legend of the ownership certificates or stock certificates some of the restrictions that relates to transferring interest. So no individual owner can try and trick a lender into lending them money and then giving them that share as collateral for the loan or something of that nature. Next slide. And the final thoughts: when building a buyout agreement, it's best to have an attorney review it. It's probably best to have an attorney help draft this buyout agreement for the business. It improves the credibility and legitimacy of the document. It helps avoid conflicting statements inside of it, and there's many more benefits that would be part of that. And probably one of the key takeaways from all of this is that, you know, if you're starting a business and there's more than one owner, the best time to consider this is earlier rather than later, because earlier, when all the owners are getting along, it's much easier to come up with all of these things. When a dispute happens in the future, it can be already too late. Thank you.
John, that was great.
Thank you.
That was really good. That was a reminder, a great reminder for all of those estate planning courses. It was really good. Does anyone have any questions?
Hey, John, this is Kimberly. Thank you so much. I enjoyed the review. Out of the different ways to fund the buy-sell agreement, in your experience, which one is the most common?
So I'll have to admit I haven't seen lots of buy-sell agreements in the future, but from my experience, or in the past, but from my experience, the ones that I have seen people use in business often is using a note of some sort over a period of time, and using some cash reserves or a loan as a down payment. So you do some sort of a down payment to the business owner, and then you use a note to buy them out. The note oftentimes will come from the cash flow of the organization, but if they need to, you know, get it from the bank to help finance it, that could happen as well. But pretty rare that someone buys it all up front with cash, or all out with insurance in every single situation.
Yes, thank you. I was just thinking that if you had a family business, it would probably be pretty cool if they could utilize 2 or more by funding arrangements. In particular, I'm thinking about a client of mine who drafted a buy-sell agreement, but pretty much decided to fund it with a note. And then you fast forward in the future, this particular individual is now disabled. And it sure would have been pretty cool if it could have been funded, you know, with disability income insurance as well as a note.
Yeah, and I think you make a really good point there in that, you know, particularly when it comes to death or disability, if the business owners can afford insurance policies, that's a great way to kind of spread out the cash flow through the premiums to be able to fund that sort of change that happens. So I think most common, there would be some combination between those different ways to fund it in order to facilitate that type of transfer. So that's a very good point.
Thank you, John.
Any other questions? No other questions?
Kelly has her hand up.
Oh, okay.
Thank you. John, that was great. And I just know of a couple situations in family businesses where the family wasn't aware if the head of the family or the primary owner died, that the family would have to sell the business, and other family members want to keep it going. So do you know anything about how they can overturn that kind of situation?
Ooh, well, you know, I can't really speak to any specifics on that. But if there's no agreement in place, it can be very, very challenging. So perhaps, you know, hiring some sort of mediator or an independent third party to help figure out the situation would make the most sense. You know, what you're talking about kind of reminds me of what I read about, you know, when you have maybe like two 50-50 owners, you know, because when there's two 50% owners and there's no buyout agreement, there really is no easy way to resolve it at all. They have to figure out a way to work it out. One provision I didn't really mention is called, there's a couple like this, but it's called like Russian roulette. And if you have that provision in the buy-sell, you can make it so that you have an offer to try and completely buy out from that person or sell all of the interest. And then that other person can then accept that offer, or they can counter it back to them and try and buy them out or sell. And ultimately triggering that provision is a way to try and force a sale between kind of a gridlocked situation. But yeah, the internals between a family that doesn't have a well-structured buyout agreement, I think would be complex and probably in need of an experienced third party to help them work it out.
Thank you, John.
I just have one quick question, especially in light of everything that's going on in terms of estate planning and the potential for a lot of estate planning documents to be modified with the increase in the exemptions. How often or how easy is it to modify the agreement? Let's say if somebody had an interest placed inside of a trust. Or something like that. I mean, is it a really, I would anticipate it would be a pretty drawn out process, and you could potentially end up moving backwards. Let's say if you wanted to increase the amount of interest inside of a legal document like that. Can you speak to that briefly?
I think you bring up a really good point. When people put their business interest inside of a trust, if they're not consulting with the other owners on the implications of that in the future, I think it can get very complex, because if they pass away, now the other owners have to work with that trust entity. With results to the changes in the essentially the estate law, I can't speak to that as much, but certainly having some sort of reference to that in the buyout agreement would make a lot of sense when drafting that, letting the other business owners know that that's how you're going to be structuring their interests, because ultimately everybody just needs to know where if one owner leaves, what's going to happen with their interest and how can they best prepare for that.
Okay, Cindy, well, we're at 12:30, so it was great. Thank you so much, John.
Thank you.
Thank you, John.
Thank you.
Yeah, thank you, John. Thank you for taking the time today to present this information. If anybody's interested in the financial planning program, which sponsored our webinar for today, feel free to contact our program director, Dolly Chen, or myself at the following. The information on how to contact us is on the website or on this webpage or this webinar page right now. So, and before we take off, is there anybody that has any questions or comments, or anybody who hasn't had a chance to speak? All right, with that, I'll thank John again. Thank you for taking the time today. And it was a pleasure to have everybody join us today. Thank you.
Thank you, Cindy.
All right. Thank you all.